The wide disparity in the interpretation of the provisions of the Act by the various high courts bears testimony to the fact that this enactment, which right from its inception has been shrouded with the controversies and contempt, needed a closer scrutiny and finality by the Supreme Court. Labelled as anti-women, the constitutionality of the Women Act was challenged and decided in Dania Latifi versus Union of India on the following grounds. Number 1. The Act is un-Islamic, unconstitutional, and it has the potential of suffocating the Muslim women, and it undermines the secular character which is the basic feature of Constitution. Number 2. There is no rhyme or reason to deprive the Muslim women from the applicability of the provisions of the Section 125 of the CRPC, and consequently the present Act must be held to be discriminatory and violative of Article 14 of the Constitution. Number 3. Excluding the application of Section 125 of CRPC is violative of Article 14 and 21 of the Constitution. Number 4. The remedy provided under the Act is illusory inasmuch as, firstly, she cannot get sustenance from the parties who were not only strangers to the marital relationship which led to the divorce, and secondly, Waqf boards who would not have enough means to support such destitute women since they themselves are starved of funds, and thirdly, the potential legalities of destitute women would either be too young or too old as to be able to extend requisite support. Therefore, this provision denies to women right to life and liberty and operates oppressively, unequally and unreasonably only against her and is hence unconstitutional. The government contended that personal law is a legitimate basis for discrimination, if at all, and therefore subjection of a Muslim woman to a different law does not offend Article 14 of the Constitution. In conclusion, it was held, a Muslim husband is liable to make reasonable and fair provision for the future of the divorced wife, which obviously includes her maintenance as well, extending beyond the iddat period, and must be made by him within the iddat period in terms of Section 3, subsection 1st, Clause A of the Act. His liability under Section 3 to pay maintenance is not confined to iddat period. Provisions of the Act do not offend Article 14, 15 and 21 of the Constitution.